Good morning and welcome to the Justice Human Rights Student Conference for 2015. My name is Andrea Coomber. I'm the Director of Justice, and we're delighted that you've all chosen to give up your Saturday to spend with us exploring human rights in manifestations beyond the courtroom. So looking at inquests, inquiries, and other less traditional approaches to justice. I've just lost my phone. There we go. This is a really exciting time for justice and for our student network. We last March launched a new strategy in this room by the Lord Chief Justice, launched our strategy which refocuses our work on the fair administration of justice and the rights of people in the justice system. We are delighted that a strong part of that involves reinvigoration of our student network and our student membership. And you will have seen over the last few months, and you'll be seeing in future, more and more activity with our students because we consider you kind of the future of justice. We're very proud at Justice that we have internships for which we pay for, and over the next period of time we'll be advertising for them, and we hope that you'll consider applying to come and join us. All of our interns earn the London living wage and work for 3 months out of our offices just near St Paul's Cathedral. And we've also recently launched a program of externships where, regardless of whether you live or work in London or what your personal circumstances are, you can work for Justice externally, working closely with our staff on a number of different projects. So we've just closed that first round of externships, but there will be more offered later in the year. We'll be offering blogs later in the year, and we've already had one webinar, and we'll be having more for student members of Justice. And I would encourage you to consider joining Justice as a student. As part of the new strategy, we've knocked down the membership rate for student membership down to £15. Student members of Justice are also able to come to events for members of Justice writ large. And part of that, at the moment, we have launched an appeal last October to raise £2 million in the next 2.5 years. And we've had a number of events with writers like Robert Harris and Julian Barnes, and last month, Hilary Mantel. Next month, we have Ian McEwan coming and doing a reading at Gray's Inn for us from the Children Act. And we have £10 tickets for student members, a limited number of them, to each of those events. So it's a good time to consider student membership of Justice. I'm going to quickly run you through the programme for today. We have this morning our opening keynote, which I'll introduce in a minute. We then have 3 breakout sessions, which are replicated in the afternoon. So one of them is looking at redress following conviction, which is with Jodie Blackstock, who's our Director of Criminal Justice Policy, who will stand up for you now and smile. That workshop, that breakout group, will be in the rooms directly opposite us. If you go across my architectural descriptions aren't that good, void walkway, that will be directly opposite over on this side, on the right-hand side. The other is looking at inquests and public inquiries. That's with Angela Patrick, our Director of Human Rights Policy. That is, again, across the walkway and to the left. And the other is looking at human rights and practice, which is a Q&A session, which will be around the corner in a room called NG13. There's no point telling you the room numbers, it's around the corner, and there'll be people to direct you to that after the coffee break. If you don't know which group you're in, there's a list on the table, which is again across the walkway. Please note the group that you've been allocated to and go to that group, otherwise we will have people in all kinds of weird configurations. So they are again replicated in the afternoon, so you go to a different session in the same rooms in the afternoon. And then we have an afternoon, at 3 o'clock we have a review of the year in human rights by Angela, and then an afternoon keynote at 4 o'clock, and we'll finish around 5 o'clock this evening. 2 thank yous before we start the day. The first is to Freshfields for providing this fabulous venue for us and for providing lunch and their general support of justice, which is extraordinary. Freshfields have very generously given us £25,000 towards our appeal, so they are one of our favourite law firms, and we implore all of you to think kindly towards them. The other is the University of Law, which is providing sponsorship for today. We have a number of students from the University of Law here. They are wearing University of Law, discreet University of Law, very stylish, University of Law t-shirts. So if you have any questions about the University of Law, then please feel free to speak to one of them. But we're very grateful for their support. Well, moving on to the programme, our first keynote this morning is by Leslie Thomas QC. Leslie is a barrister working at Garden Court Chambers, specialising in civil liberties, human rights and inquest law. He's represented the families in many high-profile inquests, and I'm sure he'll talk about some of them, but including Mark Duggan and Anthony Granger and the Hillsborough families. He has been named Legal Aid Lawyer of the Year in 2012, and last year he was the Lawyers Hot Lawyer Award in the field of campaigners. It's always a little humiliating, these kind of titles. And last year he took Silk. We're very proud that Leslie serves on the Justice Council, and we welcome him to address you.
So I'm just setting my timer. Good morning, everyone. But until that moment, I'd never realised what it means to destroy a healthy, conscious man. When I saw this prisoner step aside to avoid the puddle, I saw the mystery, the unspeakable wrongness of cutting a life short when it's in full tide. Eric Blair, otherwise known as George Orwell. That's from a collection of his short stories or essays. When I started in this job 26 years ago, I knew little about human rights. Yes, we had the ECHR, but it didn't really come into the law that we practiced. I studied civil liberties at university, but came to the realisation that it was a difficult concept, mainly because we had no written constitution. And with our judge-made law, our system of precedent, our rights could be evasive, fluid and constantly changing, very much dependent on the whim of judges, their interpretation, only subject to a Wednesbury test of reasonableness. It was all so difficult. 800 years ago was a monumental time in the history of the world. Fundamental changes came into force on a small, cold, wet, rather windy set of isles, which would impact on our lives some 8 centuries later. The Great Charter, or the Magna Carta, established the principle that everyone, including the king of the time, was subject to the law. This much-used phrase you'll hear repeated in your lifetime in many variations. No one is above the law. Everyone is subject to the law. The law applies equally to all. A medieval semi-French king who had his back against the wall, he had lost his inherited lands in France to the then French king. He was broke. He was substantially weakened in England, trying to raise taxes. The powerful barons of the land were fighting back. They said enough is enough. And they brought a list of their complaints to the king, who signed a peace treaty at Runnymede near Windsor. Why does all of that matter today? Simply because it is the cornerstone of all modern written constitutions. It is the basis of many of our human rights, freedoms, which we enjoy today. One of the most famous clauses in the Magna Carta, clause 3940, reads as follows: "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed, or exiled, or deprived of his standing in any other way, nor shall we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. To no one we will sell, to no one deny or delay the right or justice." This is all great rhetoric, isn't it? It's the foundation of our civil liberties, human rights, and the stuff of great speeches. But it is more, sorry, excuse me, switch this on silent. It is more important than that. What does it mean no one should be seized or imprisoned? No one should be stripped of their rights or possessions. People have a right to a fair trial, an entitlement to due process. No one shall be denied or delayed justice. Well, this great charter has acquired special status because despite the fact that the vast majority of its clauses have now been repealed or superseded by other legislation, it has enormous symbolic power as an ancient defence against arbitrary or tyrannical state power and a guarantor of our individual freedoms and liberties. Arguably, the most fundamental and important right we have is that of life. Without life, we have nothing. Which brings me to the work that I do. Everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of the court following his conviction for a crime for which this penalty is provided by law. I'm sure those of you who are human rights scholars will recognise that being Article 2 of the Human Rights Convention. Briefly, Article 2 involves the following duties: a negative obligation on states to refrain from taking unlawfully life, a positive obligation on states to take appropriate steps to safeguard the lives of those within its jurisdictions, and an investigative obligation to look at and investigate life when life has been taken. There are general duties on the state: put in place a framework of laws, precautions, a means of enforcement which will, to the greatest extent, reasonably, practicably, protect life. Training, state agents giving instructions, introducing regulations, systems, all with a view to protect life. This duty arises irrespective of whether there is a real and immediate risk to life. For example, it's appropriate to investigate the adequacy of guidance for police restraint, systems for the investigation of complaints against general practitioners, even where the acts of individuals surrounding the death may be entirely blameless. Now, I want to talk to you a little bit about the investigative obligation, the Article 2 investigation. You're going to hear a little bit more about this later on, but it was really established in a case called McCann, which against the UK, which you will remember. It's the Death on the Rock case involving the 3 IRA suspects who were shot in Gibraltar. And it's based on the need to make the substantive Article 2 protections effective in practice. And that duty, that investigative duty, has been developed in the case of Jordan. Again, you're going to hear a little bit more about Jordan in a later talk. But it has been embraced and taken on board in our jurisdiction, and particularly in the area of law in which I practice, coronial law. There are minimum standards when you have an Article 2 investigation. The investigation should be independent, the investigation should be effective, next of kin should be involved to an appropriate extent, the investigation must be reasonably prompt, and there must be a sufficient element of public scrutiny. Well, what does all this mean? We have been told that the Article 2 procedural duty involves ensuring that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that where there is the suspicion of deliberate wrongdoing, if unjustified, it's allayed. We should be able to identify dangerous practices and rectify those procedures. And we should ensure that lessons are learnt that may save the lives of others. Well, that brings me very neatly to my work. Let me tell you a little bit about my journey and what I do and my early years of practice. I start with a quote, and it's my quote actually. When I did my first inquest in 1990, I quite frankly didn't have a clue. I was told that the hearing would be a short matter. I was very junior counsel then, just out of training, and the coroner's court was the forum where junior, inexperienced counsel were sent to learn their trade. It was a time when it was generally thought by many in the profession that inquests weren't really important cases. They were certainly not lucrative if one was representing the interests of the family, since there was no legal aid. I would do my first case pro bono, in other words, free of charge. I believe this was the reason why such work was readily available for junior members of the bar. I attended my first hearing thinking it would be a short, simple affair. It was not. Yet I had no papers apart from a back sheet from the solicitors and a witness statement from the mother of the deceased. Her son had died whilst being restrained by police. He was a drug addict, had been on cocaine, he'd been arrested, struggled with several police officers, suddenly gone limp and died. I had no post-mortem report. That evidence would be provided at the inquest. This was a time when there was no disclosure of witness statements or evidence. I did not know what the police officers would be saying. I had a couple of days to prepare for the hearing. I didn't know where to start. I asked various members of my chambers, and I was pointed to the leading textbooks on the subject. There were 2 at the time. They were not practical. They talked about treasure, the great history of the coroner's court, and the law, but they did not tell me what to do or what I should expect. The language was complicated, the books were full of legal theory and case law. I asked some of my colleagues and they gave me some advice and assistance. When I attended the hearing, I was shocked. This was no small or quick hearing. It was intense and complicated. I had a grieving mother to deal with. I had no idea how to cope with grief. The mother pointed out that there were many witnesses who were not there, who she did not see at court. Where were they? There were several police officers to give evidence. They were represented by very senior counsel. The chief constable was separately represented. I noted that both counsel for the police interests, although they had different clients, sat together, conferred together, colluded together. I was excluded from all their discussions. It was definitely us against them, despite the fact that I had read in the learned books that the inquest was not a trial. There were no parties. It certainly felt that way. The hearing started and I felt thoroughly outnumbered. The coroner was cold and hostile. I asked him for his witness list, which he reluctantly gave me. If you must, Mr. Thomas. I could see that there were a number of witnesses which were just being read. Most of them were independent witnesses, bystanders. I inquired why they were not being called. The coroner said he had reviewed the papers and their witness statements, and there was not much they could add to the evidence. I hadn't seen their witness statements, and I asked whether I could do so. Again, reluctantly, he said, If you must, Mr. Thomas. The jury was sworn, the witnesses were called, I heard their evidence for the first time. I noticed that everybody else in court had their witness statements. I was the only one who had no papers. I was hurried by the coroner when I asked questions. I inquired whether I could see the statements or the notebooks. The other barristers objected. The coroner upheld their objections. Do get on with it, Mr. Thomas. Well, the evidence, it was clear that there were contradictions between what was being said. There was contradictions between the live evidence and the read evidence. But the coroner did not call the independent evidence. I did not feel brave enough to ask him to do so. The pathology evidence was equivocal. He, the pathologist, was unsure as to the cause of death. He thought the drugs had played a part, but also the struggle. He did not consider or comment on the restraint. I knew nothing in those early days about the concept of positional asphyxia. At the close of the evidence, I asked about my right to address the jury and was told I had none. I could only address the coroner on the law and the verdicts. I sat down with not much to say. The jury returned an open verdict. It was an experience I will never forget, and I was determined one that would never happen again. The journey. Positional asphyxia. This is a mode of death where an individual is held or restrained in a deleterious position which inhibits the mechanics of breathing. How did I learn about positional asphyxia? In 1995, there was a young man by the name of Wayne Douglas. Wayne was an interesting soul. He came from a troubled background. I make no excuses for Wayne. And despite coming from a loving family, one evening decided to commit a household burglary, whereby he broke in with a knife into the home of a young couple who lived just off Acre Lane in Brixton, South London. He escaped and was running through the streets of Brixton. The Brixton police came out in numbers. He was seen, he was cornered, he was apprehended, he was restrained. During the course of the restraint, Wayne died. Wayne's death, for those of you who are old enough, you maybe remember, it sparked the Brixton riots in the 90s. Not the first Brixton riots, but the second Brixton riots. It was a controversial case. I was instructed in this case to represent Wayne's sister. I remember this case well. It was my first big case. There was a difference though. This time I was ready. I remember the pathologist who gave evidence in this case. His name is Dr. Freddy Patel. You might want to Google Freddy Patel. I shall say no more. Dr. Patel was instructed on behalf of the coroner, and he gave the most amazing evidence. During questioning by myself, Dr. Patel said that positional asphyxia was a myth. The jury rejected his testimony. Although the verdict wasn't one that we wanted, it was accidental death, we had come some way because the jury found that the death was contributed to by restraint and positional asphyxia. Despite the verdict, there was a challenge because the coroner had confused the jury in his summing up with the definition of unlawful killing. He combined and conflated unlawful act manslaughter with gross negligence manslaughter. This went to the Court of Appeal in a case called Douglas Williams. You might want to read it at some point. It's an important case and still is an important case in coronial law. Although the Court of Appeal in the judgment of Lord Wolfe came to the conclusion that the coroner was wrong and had misdirected the jury in law, they didn't overturn the verdict. They said it would have made little difference. There was no new inquest. This taught me an important lesson. Even where the law is clear-cut, the decisions of judges are not. This was certainly a low point. Second case that I want to talk about on my journey, Ibrahima Say. This was another interesting landmark case because Mr. Say died in 1999. His death was interesting because it was the first death in this country after the introduction of the CS spray trials, which had been introduced. Here you had a man clearly suffering from mental health problems. His wife calls the police. She wants him helped and given medical assistance that he requires. The police arrive from Forest Gate and an Ilford police station, if I remember rightly. He's restrained. He's sprayed at close range. He dies in custody. Say was an interesting case for a number of reasons. One of them I've already indicated because he died, this being the first case of its type after the introduction of sear spray. But it was a long and difficult case, and it was interesting because I began to see a pattern emerging. Did you know there's something unique about the black man? The black man has superhuman strength. When he's restrained by a number of police officers, he's able to resist. Sear spray doesn't work on the black man. And so on and so forth. This was a recurrent theme that I began to notice in my years when I did a number of these cases. Interestingly enough, despite this long and difficult case, and despite the fact that the jury heard evidence that, Ibrahima, despite being sprayed in the face and was licking the sear spray and drinking it and it having no effect on him, and despite the fact that he died shortly afterwards, having been restrained, they found that he died from a combination of positional asphyxia and restraint. Another interesting thing about Say was the inequality of arms. Again, this was another case that I did pro bono. In fact, Raju Bhatt, who is going to be giving you the afternoon keynote speech, was my solicitor on that case. Those representing the state are paid for by taxpayers' money, your money, my money. Begs this question, doesn't it? If an individual dies in the hands of the state, why should they have to fund, or why should their family have to fund their investigation? This case was a success because we had a verdict of unlawful killing, which was returned by the jury. The low point, though, was despite that finding, despite that verdict, and despite the fact that the Crown Prosecution Service were under an obligation to review the case afterwards in the light of the verdict, they decided not to press or bring any criminal charges. The year 2000, Christopher Older. This case has to be the case which has had one of the biggest negative impacts on me in my personal and professional life. If you do this work, know this: you become a target. Christopher was an ex-paratrooper. He served Queen and country. He was a young man in his mid-30s. He got into the fight one night in a nightclub, the sort of thing that young men, ex-soldiers, tend to do. He received a blow to his head and was taken to a local hospital. He was difficult in hospital, probably because of post-concussional syndrome, and the police were called. He was arrested, taken to Hull police station, and the police officers dragged him into the police station. He had unexplained injuries other than the blow that he received in the nightclub. The incident was captured on CCTV. His trousers were around his legs. He was exposed. He was not in a decent state. He was put on the floor of the police station and there left to die. I say there left to die because that is precisely what happened. You had 5 police officers standing around the custody suite, talking amongst themselves, completely oblivious to the fact that Christopher is on the floor, groaning and moaning, and the life is practically ebbing away from him. You actually hear his last gasp for breath, and then he dies. Upon which all panic breaks out in the custody suite when the police officers realise what has happened. It was another interesting reason for Christopher Older because, again, this was a case which again highlights the difficulties that those of us who do this work and represent the Davids against the Goliaths have to face. There were no less than 9 interested persons representing various state agents against me. Things hadn't changed that much from the very first case that I read you the quote about the colluding, the conferring, excluding you from their discussions. I felt so lonely and isolated up there in Hull. It's the first case I've done where, when the CCTV was shown, the jury cried at the inhumanity of man towards man. It was a battle. We had an unlawful killing verdict returned in the end. There was a prosecution, but during the prosecution, the judge stopped the prosecution. Another low point in the sense that you have this disparity between jury verdicts in inquests and the criminal justice process. So far, I've been talking about restraint-related deaths. Let me move on to another theme. Police shootings. 1999, James Brady, a young man who grew up on the wrong side of the tracks. got in with the wrong crowd and was involved in a non-domestic burglary. The police had intelligence, were called, and were ready for the burglars. As James is exiting, he's the last one out, his friends get away, a window in this warehouse, I believe it was a warehouse, I could be wrong. He's said to have turned and he's shot dead by the police. The circumstances behind his shooting were controversial. There was a real issue as to whether the shooting was indeed reasonable and proportionate. Interestingly, this was a case where the officers first successfully applied for anonymity. If you're interested, the case is A against Her Majesty's Coroner for Newcastle. Despite the fact that the police were saying they were justified in shooting James, in other words, there was no other justification which was put forward, so they were saying he was lawfully killed, the jury rejected that and returned an open verdict, which, if you think about it, is a success. Because the jury is saying, we have doubts as to whether or not this was justified. Foster Thompson, 2004. Another young man who was shot in Bristol. I was representing Foster's family, again in reasonably controversial circumstances. Again, it was suggested that Foster, who it was said was armed, involved in a robbery with an associate, was running from the police, and as he's running from the police, he turns, aims a gun at the police, and the police shoot him in self-defense. There's one problem, though, with the police account forensically. Foster was wearing a high fluorescent jacket with 2 stripes along the back. He was shot in the back between the 2 stripes. There was an issue as to whether or not at the time he was shot he was turning like that. The jury rejected our argument and found that the shooting was lawful and justified. For me, that was a difficult case because I didn't think that the forensic evidence supported the account. But you have to take the highs with the lows when you do this job. Another controversial case. Andrew Markland and Christopher Nunez. This is a case I did in 2011. Really controversial police shooting. Why? Because it's the only case that I know of where 2 men are shot at the same time by the police, dead. Nunez and Markland were no angels. You will see that when you do this work, half the time the deceased aren't angels. But ask yourself this question. The fact that somebody's not an angel, does that give the police the right to take them out if there is no justification for the shooting? Their death, Mr. Nunez and Mr. Markland's, was captured on CCTV. This case was interesting because it raised real problems about the use of secret materials, covert evidence, which is kept from the families of the deceased so that we don't know or don't have the full picture in relation to the intelligence that the police have at the time they are conducting their undercover surveillance of the deceased. It's a real problem and a theme that I was to return to in the case of Azelle Rodney. Azelle Rodney, recently, the inquiry was in 2012. The report, public inquiry, the report was in 2013. You may remember this case. Azelle was shot 6 times by a police officer by the name of Anthony Long, who is now up on a murder charge in North London. Azelle was with a group of men driving a Golf across North London. To be honest with you, I really don't know what was in the minds of Azelle and his comrades, but they were going to do a drugs rip-off from a group of Colombian drug dealers. Maybe not the wisest thing to do. In any event, the police had intelligence that this rip-off, so one group of criminals were going to rip off another group of criminals, and the big question throughout the inquiry was whether or not the police could have intervened and stopped this earlier, or whether the police were evidence gathering and waiting to the last moment so that they could capture everybody. And you can see the tension, can't you? The tension between wanting to solve crime and the tension between intervening and preserving life in a place where it's safe to intervene and preserve life. In any event, the chairman of the inquiry found that Azelle had been unlawfully killed. Really interesting report in terms of the use of force, proportionality. I do encourage all of you, if you have the time or the inclination, to read it. And it's to be found on online. It's the Azelle Rodney inquiry report. And that brings me to Mark Duggan. Well, what can I say about Duggan that hasn't been said already? You will know that in 2011, following Mark's death, that sparked widespread disturbance and rioting across the UK. Again, a case that raises very similar issues to Azelle Rodney in terms of whether or not the police should have acted on intelligence earlier and made an arrest earlier. You know the verdict of the jury. They found that the killing was justified, despite our arguments to the contrary. I want to move on in the short time that I have. The work that I do doesn't just involve the high-profile restraint deaths or shootings. There are times when you do this work where it involves the state's failure towards the vulnerable. And I want to just mention a couple of cases to you. There was a case I did in 2006 of a young, not a young woman, she was a woman in her 40s called Mandy Pearson, who just was somebody who had mental health problems and self-harm issues, who ended up in H&P Newhall. Mandy was found hanging in her dormitory cell in the healthcare centre. She had a long history of serious self-harm and mental health difficulties, but despite persistent and regular threats of suicide, she was never placed on a suicide or self-harm watch in the weeks before her death. In their narrative verdict, the jury stated that prison wasn't the best option for Mandy, or others in a similar position. There appears to be a dearth of effective alternatives, which mean that they are imprisoned within the justice system. The jury highlighted shortcomings in the prison management of Mandy's risk of self-harming, stating that Mandy had been seen by a number of staff who made the assumption that she was on a self-harm watch. This highlighted clear inadequacies and in the communication in the prison between healthcare staff and prison staff. They found that there was a lack of appropriate training and inadequate support of the staff responsible at the time. Now, Mandy's case completely shocked me, but one more case I just want to mention to you, which really sums up this work. And it's the case of Petra Blanks. Another young woman. Petra was 19 when she died, in H&P Newhall. The inquest heard how Petra's problem started when she was 5 years old and her parents divorced. She and her identical twin sister were beaten by their mother. Sometimes they were locked in a cupboard with dogs at their home. When she turned 9, social services were called in. The twins were sent to live with different foster carers because they fought so much. The pair were reunited a few months later when they were placed in the care of a foster family. But the inquest heard evidence that Petra was abused sexually whilst she was in care, triggering episodes of self-harm, which would become a pattern in her short life. She was moved to a children's home where at 14 she was raped. Her self-harming episodes continued and increased dramatically. At the home, she became pregnant by a teenage boy who refused to have anything to do with her or her son. She was moved by social services into a halfway house for young mothers. The inquest heard that Petra struggled to bring up her son as she continued to self-harm. She asked social services whether they could find a nursery place for a 2 or 3 week respite break, but her request was rejected. In December 2002, Petra suffered a breakdown and tried to commit suicide. She was sectioned and the son was taken into temporary foster care. Several times while in the psychiatric unit, she said she wanted her son adopted. And then on other occasions, she said she wanted to keep him. 3 months after being admitted to Tameside, Petra was released. She was judged to have a borderline personality disorder, which, according to the hospital, was not treatable under the Mental Health Act. Instead, it was decided to treat her as an outpatient. 8 months later, she was dead. Just after 4 p.m. on the 7th of July 2003, Petra telephoned Derbyshire's Community Psychiatric Team. She told them she had cut her wrists by smashing her hands through the window of her flat. Just pause in there. If that's not a cry for help, what is? When the team arrived, they found that Petra had tried to gas herself, but no one reassessed her mental state. One team member told the inquest that they had known her condition was untreatable, so there was no point. It beggars belief that a cry for help that loud was ignored. Petra's plight was not uncommon according to the experts. We receive a large increase in our calls to our helpline from people with borderline personality disorders who cannot get help, said one chief executive of a mental health charity. Things went from bad to worse. Petra was left on her own after the team came out. They left her. 3 hours later, she set alight to her mattress. Alarmed by her actions, she phoned the fire brigade. Another cry for help, you might think. She was arrested, charged with arson. The local magistrates remanded her because they said that she had endangered life. She was put into prison, and over the next 130 days whilst in prison on remand, she was involved in at least 90 episodes of self-harming, many requiring hospital admission. She was eventually successful. I could go on and on and on in terms of the cases that I do. But you may well think to yourself, well, why is this case, or this line of work important? Particularly when you see repeating, recurring themes. What's the point? I'm often asked, Leslie, do you feel you're successful when no police officer has ever successfully been prosecuted? And that reminds me of a poem that I read recently, actually, but it's a wonderful poem. It's by Edgar Albert Guest. It couldn't be done. Someone said that it couldn't be done, but he with a chuckle replied that maybe it couldn't, but he would be one who wouldn't say no till he tried. So he buckled right in with a trace of a grin on his face. If he worried, he hid it. He started to sing as he tackled the thing that couldn't be done, and he did it. Someone scoffed. Oh, you'll never do that. At least no one has ever done it. But he took off his coat and he took off his hat, and the next thing we knew, he'd begun it. With a lift of his chin and a bit of a grin, without any doubting or quit it, he started to sing as he tackled the thing that couldn't be done, and he did it. There are thousands to tell you it cannot be done. There are thousands to prophesize failure. There are thousands to point out to you one by one the dangers that wait to assail you. But just buckle in with a bit of a grin. Just take off your coat and go to it. Just start in to sing as you tackle the thing that cannot be done, and you'll do it. Thank you.
Thank you, Leslie, for what has been an amazing insight into not only the professional challenges but the personal challenges of doing this kind of work. Leslie's very kindly offered to take questions. So I think we have some microphones. Somewhere? Do we have microphones? Yeah, we'll find some microphones. Does anybody have a question for Leslie? Yep. If you want to stand up and speak loudly, maybe just say who you are and where you're from.
My name is Anna Cullen. I currently work for a number of House of Lords. Thank you for an incredible, really incredible speech. I was just wondering, what do you think about the responsibility of the government when they purposefully and knowingly ensure that somebody becomes a target for others? The example I would give is, for example, when Phil Shine the lawyer that Petra know about, but he was called out, called terrible names by Michael Fallon and others, and when because of executive action, that person becomes a target. What is the role of what is the responsibility of the government to ensure his right to life in that situation?
Well, I know about what's happened to Phil. I just think it's absolutely outrageous. It's a real attack on all of our fundamental liberties when you do a job, or you do this job, and you are vilified for it, you become a target, you are spied upon, you cannot have private or secret communications with the people that you are trying to represent. And it's a fundamental challenge to our very basic liberties and rights. You know, if they're coming for the lawyers, you know, what does it say about the people that we represent? I think it's shocking. I think it's really outrageous. And I would encourage all of you to sign there's an online petition, and I would encourage all of you to sign the online petition, making your voices clear that this is something that we will not tolerate.
There was another question at the back.
You said a little bit, you said in whole, could you jump on the other side and that made things difficult? Could you say a little bit more?
Yeah, the whole purpose behind having different interested persons, they're not parties, you see. There are no parties in an inquest because they're not meant to have sides. But the whole purpose behind having the chief constable and the individual officers separately represented is because on the face of it, there's a conflict. That's why the chief officer has his own barrister, and the individual officers have their own barristers. There's a conflict. If there was no conflict, they would be represented by one counsel. Now, despite the conflict, when they are all putting their heads together and literally exchanging their skeleton arguments, exchanging their arguments, when you walk by, they suddenly clam up. Oh, look, Leslie's walking by. You know, let's not say anything. You know, it's just ridiculous because what it means is you are literally against a body of lawyers all singing from the same song sheet, which makes the whole equality of arms argument a bit of a nonsense.
This gentleman in the front.
I'm just wondering if you could comment on your experience of the speed and efficiency of inquests, and if there's any way that could be improved.
The chief coroner introduced a guidance that most inquests should be heard within 6 months. In exceptional cases, they should be heard within a year, unless there are good reasons. So that is really the parameters at which an inquest should be heard. But there's a difficulty, and it's this. In controversial deaths, so restraint deaths, shootings, there generally is parallel investigations going on. Yeah? So take a police shooting just by way of example. You will have the IPCC, the Independent Police Complaints Commission, doing their own independent investigation as to whether or not the shooting was justified. The IPCC investigations take, on average, in excess of a year. You can immediately see the difficulty with the parallel investigation running with an inquest. Because an inquest is just not going to start until the IPCC's investigation is concluded. And you, as the lawyer representing any of the interested persons, whether that be police interests or the family's interests, aren't going to want to run the inquest until the IPCC have concluded their investigations. One reason would be that you want to see all the evidence, and that, there may be evidence that comes out in the IPCC's investigation that would be useful to know in the inquest. But it doesn't stop there, because after the IPCC have concluded their investigations, a decision is generally made by the Crown Prosecution Service as to whether or not they are going to take any action in relation to, say, a police shooting. And again, you wouldn't want to run the inquest until you had that conclusion. And in fact, you couldn't, because if there's criminal proceedings, then the inquest gets kicked into the long grass until the conclusion of the criminal proceedings. So just those two investigations can really delay the inquest. Now, the part of your question that you're asking, is there anything that can be done about it? Well, yes. Those other state bodies, state agents, those watchdogs, they could be more efficient and speed up their processes. But we have to bear this in mind. Although these processes do take a long time, we don't want expediency at the sake of justice. And I've seen that on a number of cases where you have a new breed of coroner who wishes to really rush the inquest through because they know that they've got this 1 year time limit in their heads, and they're pushing everybody, and nobody's prepared or properly prepared for the inquest, and you haven't had disclosure, and that could be really problematic.
There was another person at the back. Oh, sorry, it was this person here I was thinking of, sorry. And then we'll have you, sir, and then we'll be finished.
Who was it?
There was somebody around there? Yeah.
I was going to ask a question, but I wasn't sure if it was entirely relevant, but I'll try. Given the appalling cuts to legal aid, I just wanted to know what the impact would be on people's ability to access human rights that you've been describing today.
Really difficult. Firstly, there's the general cuts to legal aid that we're all aware of, which makes it really difficult. But a lot of people have been taken out of scope, and to run these cases, the cases I do, most of the cases I do engage Article 2, and there is an obligation. You generally will get legal aid for these Article 2 cases, but there are a lot of cases that are borderline, or where a coroner refuses to engage Article 2 and there's no funding. And so the irony is we then go back to the position that we were in when I started in the 90s, where there was no legal aid. Can you imagine? No legal aid for these cases. And it would be a shame if we go back to to those days. The second thing about legal aid is, and I know people talk about fat cat lawyers, but the other attack just isn't on access, but it's also on rates. And there has been huge cuts in the rates that lawyers like us who do this work are getting. Now, you may well think, well, lawyers bleating on about their money, but a lot of the lawyers who do this, do this sort of work at really, really low rates, and that oughtn't to be forgotten.
And the gentleman, sorry, there's a gentleman at the back here.
Thanks. I was just wondering, I had a conversation with my taxi driver this morning in which he said that human rights has been hijacked by criminals. And of course, you've got a major political party talking about repealing the Human Rights Act. And why is it that some people don't see human rights as important?
It's to do with just education, isn't it? And getting the message about human rights have been given such a bad press. I just shake my head, because extreme cases are what are highlighted, but there are so many smaller cases which touch the lives of all of us, which are human rights cases, which never get reported or highlighted. And there are individuals or agents who have an agenda, and it should come as no surprise whatsoever that those who argue that, you know, human rights are just, you know, a handful of criminals who are pushing their rights. When you scratch the surface and look at what their agenda is, it's generally, you know, government agencies who allow this rhetoric to be pushed because it's the government who's being challenged.
That's great. I'm afraid this lady here, I'm sorry, we won't have your question, but I promise you, because Leslie's lovely, he will talk to you personally in the coffee break. Okay? I'd like you all to put your hands together for Leslie for a fabulous.